Okay, so we've got to talk about this whole Georgetown law thing.
Yeah, this is a big one for sure.
This could be huge. It's like straight out of one of those dystopia novels where the government starts dictating what can and cannot be taught in universities.
It really raises those kinds of questions, doesn't it? Like, where does the government's authority and academic freedom begin?
Exactly. We're talking about the U.S. Attorney for the District of Columbia basically saying to Georgetown Law, hey, your teaching on DEI is unacceptable and there will be consequences.
And when you dig into the specifics of what the U.S. attorney allegedly said in this letter, wow, it's pretty alarming.
For sure. So to make sure we're all on the same page for this deep dive, we've got a few sources we'll be pulling from. We've got excerpts from a YouTube video by Glenn Kirshner, a former federal prosecutor who's now a legal commentator, and he's definitely not mincing words about this situation.
Right. And we've also got a Reason Magazine article, which, they tend to lean libertarian, so they're coming at it from a slightly different angle. And of course, we've got the Associated Press coverage to give us the straight news reporting on it.
So what we're going to do is try to piece together exactly what happened, what's being alleged, what Georgetown Law's response has been, and then try to unpack what this could all mean. The potential ripple effects for universities and students, and maybe even for, the future of education in this country.
Absolutely, because this isn't just some isolated incident. This has the potential to set a precedent that could impact us all.
So let's start with the alleged letter from the U.S. Attorney, his interim U.S. Attorney Ed Martin, to Dean Triner over at Georgetown Law. What exactly does it say?
Well, according to the YouTube video, Kirshner actually quotes from the letter, and it states that Martin received what he calls reliable information that Georgetown Law continues to teach and promote DEI. Now, most people listening probably know what DEI is, diversity, equity, and inclusion, but it's worth reminding folks because it's become kind of a hot button term lately.
Right. And the U.S. Attorney didn't just express concern about DEI. He went further and straight up declared it unacceptable. That's a pretty loaded word, wouldn't you say?
Unacceptable. That's not exactly subtle language, is it? And he didn't stop there. The letter also mentions that an inquiry into this matter has begun. So he's not just making a statement. He's suggesting that there will be some kind of formal investigation.
Wow. Okay, so then the U.S. Attorney reportedly lays out some specific questions for Dean Triner questions that are, let's just say they're pretty pointed.
Yeah, the first one asked whether Georgetown Law has eliminated all DEI from your school and its curriculum. And then the second one gets even more direct, asking if DEI is found in your courses or teaching in any way, will you move swiftly to remove it?
Wow. So he's not just asking about whether they're teaching DEI, he's demanding to know if they're going to get rid of it, if they are. And here's where it gets really troubling, because the letter allegedly goes on to talk about the implications for Georgetown law students, specifically those who might want to work for the D.C. U.S. Attorney's Office.
Right, this is where it starts to feel like a real threat. The letter reportedly states that no applicant for our fellows program or summer internship or employment in our office who is a student or affiliated with a law school or university that continues to teach and utilize DEI will be considered.
So it's not just about the curriculum itself. Now it's about tying it to these very tangible career opportunities for students. That's a pretty significant escalation, wouldn't you say?
Absolutely. And it really underscores the potential power imbalance here. You've got a high-ranking government official essentially saying, if you don't comply with my demands, your students will be blacklisted from certain career paths. That's a pretty bold move.
Yeah, and to add to the pressure, the letter reportedly gave a deadline for a response, Monday, February 24th, 2025. So they're not messing around here.
Not at all. So we've got this very clear picture of the U.S. Attorney's stance. Now, how does Georgetown Law respond?
Well, it sounds like Dean Triner came back swinging. He didn't just back down or try to appease the U.S. Attorney. He issued a pretty strong defense of the university's right to teach what they see fit.
Yeah, Dean Triner sent his own letter back to the U.S. Attorney, and he goes straight to the big guns invoking the First Amendment. He basically argues, hey, the government can't tell us what we can and cannot teach. That's a violation of our fundamental right to freedom of speech and academic freedom.
It's a powerful argument to make. And the implications go way beyond just Georgetown Law. I mean, this could impact universities all over the country.
Absolutely, because if the government can dictate what one university can teach, well, where does it stop? Does it apply to all public universities, private universities, K through 12 schools? What about libraries or museums?
It's like a real slippery slope, isn't it? So let's get into the specifics of Dean Triner's arguments. What exactly did he say about the First Amendment?
Well, he stated pretty plainly that the First Amendment prohibits the government from dictating what Georgetown's faculty teach or how to teach it. He's making it crystal clear that he sees this as a direct infringement on their constitutional rights.
So he's not pulling any punches here. And he goes on to connect this to Georgetown's specific mission as a Jesuit and Catholic institution, right?
Yes, he argues that the U.S. Attorney's letter is not only a constitutional violation, but also an attack on the university's mission as a Jesuit and Catholic institution.
So he's saying this isn't just about academic freedom in general. It's about Georgetown's specific identity and values.
Exactly. And he elaborates on this, saying that Georgetown was founded on the principle that serious and sustained discourse among people of different faiths, cultures, and beliefs promotes intellectual, ethical, and spiritual understanding.
It's a pretty core principle for a university, isn't it? The idea that you expose students to a wide range of perspectives and ideas.
Absolutely. And Dean Triner argues that the U.S. Attorney's letter challenges Georgetown's ability to define our mission as an educational institution.
So he's really framing this as an existential threat, not just to their curriculum, but to their very essence as a university.
Right, precisely. And then he ends his letter with a direct challenge to the U.S. Attorney regarding the treatment of Georgetown-affiliated candidates.
Yeah, he doesn't let that hiring threat just slide by, does he?
Nope. He states that he looks forward to the U.S. Attorney confirming that any Georgetown-affiliated candidates for employment with your office will receive full and fair consideration.
So he's basically calling the U.S. Attorney's bluff, saying, okay, if you're serious about this discriminatory hiring practice, then say it outright.
Right. It's a very bold move. And it kind of puts the ball back in the U.S. Attorney's court.
Now let's shift gears a bit and look at the analysis from that YouTube video by Glenn Kirshner. He's a former federal prosecutor himself, so he's coming at this with a lot of insider knowledge.
Right, and he doesn't hold back at all, does he? Nope. He calls the U.S. Attorney's actions a breathtaking abuse of power and abuse of office. He even goes so far as to say that it's potentially the most egregious abuse of prosecutorial power he's ever seen.
Wow, strong words. Those are fighting words. And it makes you wonder what's behind this level of outrage. I mean, he's clearly not just disagreeing with the U.S. Attorney. He's saying this is something far more serious.
Right, and his main argument boils down to this. It is not the role of a U.S. attorney to dictate what universities teach. Their job is to investigate and prosecute crimes, not to act as some kind of academic overlord.
It's about staying in your lane, right? Sticking to your area of expertise and authority.
Exactly. And Kirshner points out that there's a fundamental separation of powers at play here. The executive branch, which the U.S. Attorney is part of, is not supposed to be interfering with the autonomy of educational institutions.
So it's about maintaining that balance of power that's so crucial to our democracy.
Right. And Kirshner then gets into the legal weeds a bit, discussing the concept of qualified immunity, which, as you know, is a legal doctrine that shields government officials from lawsuits in certain circumstances.
Yeah, it's basically meant to protect them from being sued for doing their jobs as long as they're acting within the bounds of the law.
Right. But the key question here is whether the U.S. Attorney's actions in this case fall within those bounds. Kirshner argues that they do not. He says that threatening a university over its curriculum and threatening to discriminate against its students in hiring goes way beyond the legitimate scope of a federal prosecutor's duties.
So he's saying this isn't just a policy disagreement, it's a potential legal violation. And if that's the case, what could happen to the U.S. Attorney?
Well, Kirshner suggests that if a court were to determine that the U.S. Attorney's actions were indeed outside the scope of his official duties, then he could be held personally liable. This means he could be sued and potentially have to pay damages.
Wow. So this is getting serious. And Kirshner even floats the possibility of Georgetown law taking legal action to challenge the U.S. Attorney's actions.
Yes. He seems to be encouraging them to fight back, saying that this kind of governmental overreach needs to be challenged in court. He's worried that if it goes unchallenged, it could set a dangerous precedent for other universities and potentially lead to widespread self-censorship.
So it's about protecting not just Georgetown law, but the principle of academic freedom for all.
Exactly. Now, it's worth mentioning that the Reason magazine article we looked at takes a slightly different approach. They're not as focused on the legal aspects, but they do raise some important points about the potential politicization of higher education.
Right. They argue that if the government can dictate what's unacceptable to teach about DEI, well, what's next? Could they start dictating what's acceptable to teach about history, economics, political science?
Exactly. It's that slippery slope argument again. And they point out that this kind of pressure from the government can have a chilling effect on academic inquiry, leading professors to self-censor or avoid certain topics altogether for fear of repercussions.
So it's not just about this one case. It's about the potential long-term impact on the free exchange of ideas within universities.
Right. And they also raise the concern that this kind of intervention could further erode public trust in higher education. If people start to see universities as being unduly influenced by political agendas, they might be less likely to support them or send their kids there.
So it's a multifaceted issue with potential implications for the future of education and the public's perception of it.
Absolutely. So to sum up, we've got a situation where a high-ranking government official is accused of trying to control what a law school teaches and who they hire, and the university is pushing back hard, invoking the First Amendment and the principle of academic freedom.
And we've got legal experts and commentators raising serious concerns about abuse of power, potential legal violations, and the chilling effect this could have on universities across the country.
Right. It's a complex situation with no easy answers. But one thing's for sure, this is a story worth paying attention to because it could have a profound impact on the future of higher education in this country.
And it raises a fundamental question for all of us. What are the limits of governmental power, especially when it comes to something as crucial as education? And if we don't defend those limits now, what could the consequences be down the road?
I think those are the questions we all need to be grappling with. And I'm curious to see how this plays out in the courts and in the public sphere. This is far from over.
So for you listening out there, keep an eye on this story because it could have a ripple effect that touches all of us. Think about it. What would a world look like where the government gets to decide what's acceptable to teach and learn? And what can we do to make sure that never happens?
That's the challenge before us. And it's a challenge that demands